Good evening, ladies and gentlemen. My name is Carmen Fields, and it is my distinct honor to have been invited to moderate this stellar, outstanding panel on revisiting Brown. What did it do for us? What did it do to us? The Museum of Afro-American History staff has assembled a blue ribbon commission of leaders, scholars, educators, thinkers in our midst, all of them lovers of justice and fairness. That is what they have in common, but what is thrilling to me is the fact that each member of the panel also brings very different experiences and disciplines to bear, which should make for some interesting texture for this evening's discussion. Brown v. Board of Education, Topeka, Kansas was decided May 17, 1954. It is widely held as the critical decision that overturned the 1896 ruling called Plessy versus Ferguson, which had established the separate but equal doctrine as a matter of law. The famed Brown decision resonates far beyond the classroom, however. Radio hosts Tom Joyner and Tavis Smiley recently mused to their audience that each time a black person goes into a restaurant, each time we get a room in a hotel, each time we drink from a nearby water fountain, we owe that privilege in large part to the Brown decision. That is the credit. But is there room to blame in this decision for some of the tragedies of communities of color, the loss of a cadre of teachers of our children, the dismantling of black mercantile endeavors that had promulgated a thriving middle and upper class black community? Do we blame Brown for urban renewal, once popularly derided as urban removal? Is there a buck to be passed or to stop here or somewhere? Here are some words directly from the decision. Minors of the Negro race, through their legal representatives, seek the aid of the courts in obtaining admission to the public schools of their community on a non-segregated basis. In each instance, they had been denied admission to schools attended by white children under laws requiring or permitting segregation according to race. The court contended at that time in that decision, education is perhaps the most important function of state and local governments. Compulsory school attendance laws and the great expenditures for education both demonstrate our recognition of the importance of education to our democratic society, and it is required in the performance of our most basic public responsibilities. Yea, it is the very foundation of good citizenship. Some words from the actual decision. The question of the hour: what did Brown do for us? What did it do to us? I've asked each panelist to consider their response to this question first from a professional, personal, communal frame of reference. Us is however they choose to define it. And I'd like to introduce the panel and come forward as I call your names and be seated. Born in Alabama, Honorable Margaret A. Burnham, Associate Professor of Law at Northeastern University School of Law. She is a former judge and is the first African-American woman appointed to the bench in Massachusetts. She is also a founding partner in the Commonwealth's first law firm headed by African-American women, Burnham, Dilday, and Hines. She began her career at the NAACP Legal Defense and Education Fund, litigating school desegregation cases. May I present the Honorable Margaret Burnham. Born in New York City, Honorable Nancy Gertner is now a justice in the United States District Court, District of Massachusetts. The Yale Law School grad has been critical of federal drug war policies and has been criticized for discussing pending litigation in a federal Boston school student assignment case. She's active in many human rights and judicial independence issues and is now, I am told, writing a memoir tentatively titled Lawyer with the Red Dress On. May I present Nancy Gertner. Don't forget the high-heel sneakers, Judge Gertner. Born in Boston, Jonathan Kozol is the author of the seminal book Death at an Early Age and many, many, many other documents that focus on the inequities of our society. In Death at an Early Age, Kozol describes his first year as a young white teacher in Boston public schools. He was fired for reading a Langston Hughes poem to his fourth grade students. He has had teaching stints in suburban schools and in 1991 published his observations of rich and poor schools after visiting over 30 different communities. May I present Jonathan Kozol. Born in sunny California, Professor Charles Ogletree is the Jesse Climenko Professor of Law at Harvard Law School. He is a prominent legal scholar and prolific writer. One of his more famous clients was Professor Anita Hill during the confirmation hearings for Supreme Court Justice Clarence Thomas. I would be remiss if I did not take this opportunity to mention as well that he is the lead attorney for a case in my hometown, Tulsa, Oklahoma, seeking reparations for harm as a result of a 1921 race riot. His new book, called All Deliberate Speed, Reflections on the First Half Century of Brown v. Board of Education, is available after tonight's discussion. May I present Charles Ogletree. Born in Philadelphia, Robert V. Ward is Dean of the Southern New England School of Law, a post he's held since 1999. He chairs the Massachusetts Trial Court's Access and Fairness Advisory Board. In 2000, the Rhode Island Attorney General asked Dean Ward to serve as a special consultant during the grand jury's investigation into the shooting death of a black Providence policeman by a fellow police officer. He was recently appointed to the editorial board of Massachusetts Lawyers Weekly. Dean Robert V. Ward, Jr. Last, but certainly not least, Pine Bluff, Arkansas native, State Senator Dianne Wilkerson, who is also an attorney serving in her 6th term in the state Senate. Prior to her election, she was the first African-American female to obtain partnership in a major Boston law firm. That was in 1991. Described as both tireless and driven, she led the negotiating team that resulted in community investment agreements from Fleet, Citizens, and sovereign banks that resulted in $6.3 billion in commitments to low-income and minority communities across Massachusetts. May I present Dianne Wilkerson. Now the question, what did Brown do for us, to us? Views from your own special vantage point. I'll begin with Margaret Burnham. Professor Burnham.
Thank you, Carmen.
Yeah. You have, oh, that mic is live. You can sit down. I have to stand up.
Stay here. Okay. Will do. Thank you, Carmen, and I'm thrilled to be here and thrilled to be among this illustrious company of all my colleagues, and thrilled to have another opportunity to purchase the book. The book! Like every American icon worth its salt, the opinion in Brown versus Board of Education does its work well. It elates, but as well it disappoints. It inspires, but it also saddens. It suggests a new journey, but then it brings all the old baggage with it. In other words, Brown is a quintessential American story, and this is 50 years on, a good point to look back at the long shadow that Brown casts and what it means today. Brown bashing has been a popular activity for a long time among law teachers, and some of them, in fact, have earned a good deal of their keep in this endeavor. But it's almost too easy to catalog what Brown got wrong, and it seems to me that even if one concludes that for a variety of reasons Brown didn't do much to destabilize white racial hegemony, the more challenging question is, did it hurt? Given the vicious cycle of inequality and the intractable segregation of public education today, this is really not such an outrageous question. Much of the Brown commemorations have focused on the devastating resegregation of American schools, and as well they have been an account of the legal developments leading up to Brown and the role of the courts in applying Brown's holding. And what I want to do today is look at the intersection between those two narratives, the resegregation narrative and the history of the case, and to consider whether or not, had the case taken a different trajectory, we would be in a different place today. Even in 1954, when the decision was announced, it was clear that Brown would respond to a number of issues in American culture and politics. And as we look back 50 years, we have a far more nuanced and sophisticated picture of the political crosscurrents that were at work at that time in 1954. Legal scholars and historians have begun to reconstruct a dynamic relationship between the politics of civil rights and the politics of the Cold War. This reworking of the Brown historiography dramatically widens the lens deployed by earlier scholars like Richard Kluger, whose excellent piece continues to be the classic on Brown, Simple Justice. But there is new work out now that helps us make sense of Brown and makes clear why its flaws were almost unavoidably fatal to the grand mission of equal education. When Chief Justice Warren came to the court had just emerged from one of its very darkest moments. And the Chief would, of course, lead it to its most celebrated opinion. In March of 1952, at the height of McCarthyism, Julius and Ethel Rosenberg were convicted of conspiracy to commit espionage. Massive international support for their cause put American justice under a spotlight, and ultimately that case was heard by the Supreme Court. In fact, the Rosenbergs went up to the Supreme Court on 7 occasions between 1952 and their execution in June of 1953. The case generated enormous dissension within the court. The court never actually heard the case, and upon the execution of the Rosenbergs, all pretense of the rule of law fell away in the United States. International criticism of our justice system was harsh and was unforgiving. Far from being insulated from raw politics, the Supreme Court had shown itself to be an eager participant in the rush to judgment, a rush to judgment that would embolden the McCarthy demagogues and would expose the court's own crude partisanship. Hence, when Brown, 6 months after the Rosenberg execution, when the Brown case was re-argued in December of 1953, it was argued before a court that was intensely aware of that its treatment of the Brown case would affect both international and domestic affairs. Foreign critics of U.S. race policy sneered at American democratic pretensions. And given its own sorry race record, the United States could not credibly build support among the newly independent post-colonial states, many of whom were seeking allies among the big powers. And hence the Cold War imperative impelled a new racial accommodation. In a sense, then, it can be said that Brown was significantly shaped by the corrosive effect of the Cold War on the court's work. In its earlier McCarthy-era cases and then in Rosenberg, a divided court twisted the First Amendment, twisted our criminal justice system to embrace a crude political and, in the Rosenberg case, a deadly result. So in Brown, the court needed to regain lost ground for itself as an institution, for the country, and in the ideological war over how best to frame and to secure democratic rights. So situating this case helps to explain the strategic and doctrinal constraints that Chief Justice Warren faced when he came newly to the court in 1953 and sought to garner a unanimous court for the Brown result. I would argue that that environment coming out of the Rosenberg and the McCarthy-era cases led to three strategic and doctrinal choices reflected in the Brown decision and which we live with today. One was the necessity for a unanimous opinion, and that story has been told and retold of how Warren, the consummate politician, moved across Washington seeking votes for what would be the Brown opinion, an opinion which would provide Americans with a civic lesson in democracy. But unanimity, of course, also meant that the wider issues which the school case raised, in particular white supremacy, were buried. And the second point was the focus on black pathology rather than on endemic the system of white supremacy, which again curtailed the potential reach of Brown. And a third, of course, was the severance of the remedy from the substantive violation by a year in time and by the commitment to famously all deliberate speed. Of course, it could well have been different. Had it been different, no telling where we would be today. Had the court endorsed, for example, a right to education, had it situated the issue of school segregation more firmly within the context of white supremacy, and had it not divorced the remedy from the problem, we would perhaps have a different reality. I would argue, and will argue if I have more time, I don't at the moment, that Brown has in effect been overruled by our court. Thank you very much.
Thank you. Judge Gertner, what did Brown do to us, for us?
Let me roll back the clock to a young law student in the 70s, in the late 60s and early 70s. To some degree, Brown versus Board of Education was the paradigm of equality for all subsequent groups. Whatever the critique of the decision, it was the measure of equality. Women's rights used Brown versus Board of Education both to argue that gender discrimination should be subject to strict scrutiny, that gender discrimination was illegitimate, and a host of other rights were articulated after Brown versus Board of Education. So there is perhaps the reality of the decision and its symbolism, which was considerable. It was the measure of what we hoped to be in the United States and were not yet. When I, as a judge, have to swear in citizens, for example, I stand in Faneuil Hall before a picture. And this Faneuil Hall, I'm swearing in new citizens. This should be a moment of great success for people. It should be a moment of grandeur for our society. And I researched the nature of the picture behind me. And the picture had Daniel Webster, arguably an important figure in American history. And I researched what he was doing in that picture. And I was shocked to find out that it's a picture of Daniel Webster arguing in favor of the Fugitive Slave Act, in favor of the act which required slaves that escaped from the South to be returned to the South. So there in that monument to our history is a picture celebrating Daniel Webster. So the contradictions continue and the equivocation continues. But still, Brown was a symbol for all of us. I had the pleasure of being the lawyer for the black teachers in the Garrity School case, the case against the Boston schools. And so I participated to a degree in the implementation of Judge Garrity's decree and the compromises that he felt compelled to make all along the way. And from the outset, in the years after his initial decision, the limitations of the way in which Brown was interpreted began to be more and more clear. It was as if the only kinds of race discrimination in education cases that would succeed were those in which the plaintiffs could prove that the school committee was bad and evil. We had restricted discrimination to the malevolent player, to the actor who was evil. It was as if we lost all sense of the complexity of discrimination, the way in which it endures in society, the way in which it continues in structures and institutions, and you had to identify bad intent before you could get a remedy. And then, as Margaret was saying, there was also the problem of the remedy in general. I think about South Africa at this time. If the South African government had changed and they had simply announced that this revolution was about taking down the signs that said black only and nothing more, what a tragedy the country would have been in. In other words, if all this was about was eliminating overt discrimination, the blatant, the bad actor, the malevolent person taking down the signs, and not the legacy of that discrimination, South Africa would be on a very different road than it is today. Again, continuing a point that Margaret made, when we separated out the harm and then narrowed the harm from the remedy, we went astray. The remedy became characterized as affirmative action, not the remedy for a negative act. It was seen as something special, something extraordinary, something disruptive to the American fabric, rather than the remedy for a wrong. And once it was characterized, and the language has so much to do with the way we see it, once it was characterized as affirmative action, it seems to me the issue changed. As a judge now, I am obliged to speak in part through my decisions. And I had the occasion to decide a case involving the Lynn School Committee, and I will quote from that decision so I don't get in trouble. Right? And I used the first couple of pages of that decision. This was dealing with a race-conscious voluntary transfer plan within Lynn, Massachusetts, so that if you wanted to go to a school, the city set up magnet schools with racial imbalance funds, and if you wanted to go to one of those magnet schools, you could go to the magnet school, but the city had race-conscious worried about whether you were leaving a all-minority school or a principally minority school and going to an all-white school. In other words, the transfers were viewed with a view to racial imbalance. If you wished to stay at a segregated school, that was fine. But if you wished to transfer to the magnet schools, the city would take into account issues of racial imbalance. And what I said, this was challenged, and it was challenged, and the irony, of course, is that both sides were quoting Brown versus Board of Education. Both sides were quoting Brown. And I say to the plaintiffs, the issues could not be simpler. These are the individuals challenging the race-conscious plan. Taking race into account in school transfers violates the Equal Protection Clause. The plaintiffs claim that it sends the wrong message to the children of Lynn, the message that race matters when the Constitution requires colorblindness. The plaintiffs agree that reducing racial isolation and educating students to be citizens in a multiracial nation are important goals. They also concede that the Lynn Plan accomplished these goals and even vastly improved its schools since the plan's implementation. But they claim that neither these goals nor this record are sufficiently compelling under the Constitution to justify Lynn's race-conscious school transfer policy. To the defendants, the Lynn Plan not only complies with the Equal Protection Clause, but is critical to maintaining that compliance. The plan seeks to encourage learning and good citizenship in a racially diverse environment. The message it conveys to the students is that our society is heterogeneous, that racial harmony matters, a message that cannot be conveyed meaningfully in segregated schools. In order to teach that, quote, quoting Martin Luther King, the content of one's character does not depend upon color, a child must interact with children of other races, an interaction that necessarily challenges nascent stereotypes. Without meaningful social contact, talk of tolerance and cooperation is nothing but an abstraction. If the Lynn school transfer plan were eliminated, the elementary schools of Lynn would become more and more racially segregated. And then I go on to say, while there's been a rising tide of litigation challenging racial preferences, and while courts have increasingly treated such programs with suspicion, it is not established that any government use of race for the purposes of promoting diversity is unconstitutional. To the answer to the question, can schools constitutionally use race in furtherance of education in a multiracial society, the answer is, it depends. And then I go on to say, quoting from Brown, that the setting of K through 12 education, this quote, involves a setting in which diversity has a different resonance than in any other. The goal of elementary school education is, as the Supreme Court noted 50 years ago, to foster good citizenship, not to train skilled professionals or to engage in a commercial enterprise. Thank you very much. He's going, good. And in the 21st century, good citizenship necessarily entails the ability to function in an ever more heterogeneous democracy. The case has been appealed. I don't know what will happen to it, but it does seem to me that this is a different debate, that the debate about elementary schools is a different debate than a debate about employment. And it really is the core debate that Brown initiated 50 years ago. It is the core issue that we were talking about, that children at the outset of their public school careers have to interact with children of other races. Otherwise, we are, as I say, teaching nothing but an abstraction. Thank you.
Your turn, Jonathan Kozol.
I can't help saying good when I hear what Nancy and Margaret were saying, but we're in a church, so it ought to be okay. I was tempted to say amen. It's intimidating to talk after two of my heroes have spoken and after three more people I admire, before three more people I admire about to speak, but let me answer the basic question that Carmen has posed, not by academic statistics, but simply as a witness. someone who's been in the front lines of this struggle now for 40 years. The year I began to teach in Boston, 1964, 10 years after Brown, and I'm still spending most of my life tramping through the corridors and sitting in the classrooms of similarly segregated schools in other cities. In the schools themselves, Brown obviously did a great deal in the South from roughly 1964 to 1990 and had modest impact in the North, at least as a moral challenge to us. But starting around 1990, virtually all these gains have been reversed. Percentage, oops, I said I wouldn't give you statistics, but I have to give you one. It's a devastating statistic, I think. The percentage of black children who go to majority white schools has now declined to a lower level than at any year since 1968. If you go into the schools, as I do, pretty much at random, inner city schools across the country, you see this in front of your eyes in a devastating way. And if you haven't been in a lot of schools recently, you ought to do this, or you can't imagine how much has been lost. More than 30 inner city schools I've visited the past 4 years. It's not just that they're predominantly minority, which is the antiseptic phrase the New York Times and other newspapers use. You don't see any white children in these schools at all. These are complete apartheid institutions. In the South Bronx, where my last two books took place, New York City, a little neighborhood in the South Bronx that I write about, I never see white kids, so I say, when I give lectures, I say these are segregated schools. And I don't bother with the statistics because I have good eyesight. I don't really, but I have good glasses. And some conservatives attack me. And, some of these nice fellows from genteel places like the Heritage Foundation, very sweet people. And some of them seem to like me, so they'll try to soften the criticism, and they'll say, well, Jonathan seems like a nice guy, well-intending, liberal, which I guess is a compliment, sort of. But they say the trouble with Jonathan is he doesn't give statistics. He only writes about the things he knows, which is a problem most of them do not have. So I said, this time I'm going to get me some statistics, and I did, and I'll just give you an example. In this little neighborhood of the Bronx, there are 11,000 children in the elementary schools. Of those 11,000, exactly 26 are white. Now, I'm not great in math. I went to progressive schools, but I can tell you that that's a segregation rate of 99.8%. 0.2 percentage point now mark the difference between legally enforced apartheid in the South of 50 years ago and socially and economically enforced apartheid in these northern cities now. You go into these schools, as I do, New York, Cleveland, St. Louis, Chicago, Kansas City, Denver, Seattle, San Francisco, L.A., you look around the room, you look at the faces of the children. If you have the nerve, you look them in the eyes, and you try to tell yourself this modernized millennial apartheid is what Dr. King and all our other martyrs died for. Ultimate irony is the naming of these schools. Sure, a lot of you know the old expression, and I can testify that it's true. There's an expression among black educators. If you want to see a really segregated school in the United States today, ask for a school that's named for Thurgood Marshall, Dr. King, or Rosa Parks. New York City, massive high school, Martin Luther King High, which I visit repeatedly. There are wonderful kids there. And some very good teachers, too, working against the odds. This school is not in an inner city neighborhood. This school, this huge high school, Martin Luther King High in New York, is at Lincoln Center. It's right in the middle of an affluent white community. It was put up there in order to encourage integration, in order to make it easy for white people. The black and Hispanic kids have to come by train. Washington Heights and Harlem. That school is more than 99% black and Hispanic today. It's a totally segregated school. I have a mischievous side, as Carmen will recall, from our many years of friendship. And sometimes I wonder why we agree to let them name these separate and unequal schools with colossal dropout rates, with huge impermanence of faculty, with oversized classrooms, squalid corridors that stink of the smell of sweat and hecticness, oppression, desperation. So I just wonder why we let them name these schools for the people that we love. I always say we ought to name these kinds of schools for people we don't like. We ought to name these awful schools for William Bennett or, I don't know, Clarence Thomas, But save the name of Dr. King and Thurgood Marshall for the schools that live up to their legacy. Well, we're in a church, so I had to preach.
Thank you, Jonathan Kozol. Professor Ogletree, you have a special vantage point looking at what Brown did for us and to us.
Well, thank you, Carmen, and I too am honored to be on this podium with my sheroes and heroes. Every one of these people have impacted my life in one way or the other, and we're very grateful to have so many outstanding people in the city of Boston. Brown was my lifeline. It created the opportunities to move from the depths of despair and hopelessness to the heights of opportunity and dreams. Brown was important because what we had before was racist, separatist, apartheid, and devastating. And it had one target, and only one target: people of African descent. And so I celebrate that aspect of Brown that May 17, 1954, led to the remarkable end of the official and legal and sanctioned system of apartheid. And I say that because those of you who have read the book or will read the book or read reviews about it, I'm sometimes humored by the reviewers who will find the most negative, the most narrow, the most pessimistic aspects of it and forget the larger message that Brown was important and the alternative would have been disastrous. And I didn't have to live in apartheid society. I didn't have to go to coloreds-only fountains. I didn't have to suffer the indignity of being denied an education at a place of my choice, or health care that was available if I could afford it, or housing in a community where I wanted to live, or friends who happen to be diverse in terms of their views, their gender, their race, and their origins. And so I am a Brown baby, and I celebrate that as an important and significant accomplishment. But there is also something about what Brown did to us, and it is what I would say a mixed result. There's a lot of harm, but Brown did some wonderful things to us as well. We forget that before Brown, other than the few of us who could go to Howard or Meharry or Morehouse, we weren't producing all the doctors and lawyers and dentists and educators and business leaders that we'd like to produce. We just didn't have that opportunity. And we weren't producing them at public institutions, which is important. We were paying for those institutions, but not allowed to attend them. We never were told, you don't pay, you don't attend. We always paid, but we didn't attend. And so my take on Brown is that it was an important decision, and we should celebrate the idea that the court finally had the courage to end racial segregation that an earlier court had not only embraced but constitutionalized in the doctrine of Plessy versus Ferguson, one of the most despicable decisions in the history of any civilization, not just of ours. And so that's why, in some sense, Brown should be celebrated. What it did to us is complicated as well. The good news is that it gave us people like Dr. Michael Bird and Dr. Leonard Clayton, two African-American doctors at Harvard University School of Public Health who have written a definitive text on African-American health. No one had thought about that or really been concerned about it, and their work is a classic reminder that Brown opened up some opportunities and let people of substance and brilliance write about and talk about the complexities of our society. It gave us people like Glendora Putnam, who served as the first African-American, I believe, of the Mass Commission Against Discrimination, at a time when we were suffering massive discrimination. There was a black lawyer who stood up and tried to give rights to those who needed it. It gave us people like Ruth Arlene Howe, a tenured professor at Boston College Law School, when many law schools didn't think about the idea of having a black person, particularly a black woman, on its faculty. She's a tenured professor and has been a legendary contributor to our rise. It gave us people like Sarah Lawrence Lightfoot, 30 years tenured at Harvard University, writing classic works that are timeless and important. None of these people had these occasions before Brown. Many of them weren't even, were very young at the time of Brown. It opened up those opportunities. And so we have to celebrate that. But on the other hand, and I talk about this in the book, we have to be careful about the symbolism, because we can see progress in these small ways and see these incredibly accomplished individuals and forget the larger harm. Brown didn't open the door. It simply let a few of us slip through the keyhole. I say that because I'm very proud of where I am, coming from grandparents who had no education and who knew what slavery was. I say that coming from parents who had very little formal education and knew what it meant to live in a segregated society. I come from a society having relatives who, as adults and in your senior years, never had the chance to vote, and who never learned how to read or write, and who signed their checks or their official documents with an X rather than with their name. And so Brown did some great things, but what it did to us, it gave us the false sense that we had won something for all of us, when indeed it was a palliative, it was a placebo, it was a fake cure, because it only gave something to just a few of us. And the reason what it's done to us, it's made us forget how bad the past was, because right now we don't see any difference. If you talk to a young urban woman or man, African American, in our schools, they have no idea what we talk about. We talk about segregation because they've never known anything else. When you talk about affirmative action, they have no idea when you talk about affirmative action because they've never had the opportunity to receive it. And when you talk about such basic things as the right to vote, they feel the same way Dr. King felt in 1963, that a Negro in Mississippi could not vote, and a Negro in New York didn't have anybody to vote for. And so there is a malaise, there is a pain, there is a despair in our community. And I'm not here to be negative. I'm trying to preach the truth about where we are and what we have to do. The final thing I want to say is this, that this is a problem that we can solve. What Brown did to us, it caused white people, rich white people, working white people, and poor white people to run from us. They had nothing but their race, but they were prepared to run away from urban America. It caused many of us with a little bit of resources to run from urban America as well. It calls us to turn our backs on the very institutions and the very places that gave us the opportunity to survive. And the problem of what Brown did to us, it convinced too many whites and too many blacks that being black was something negative, something unhealthy, something lazy, something illiterate, when in fact we know it's just the opposite. And so what Brown has done to us finally is to not equip us to convince those who are different from us to come back home, to come back to the community, to get deeply involved in the education of all of our children, to make a smart decision, that is to pay on the front end for quality education rather than on the back end for high-priced incarceration and incapacitation. And it calls us to see ourselves based on the color of our skin and not the content of our color. It calls us to be one of the few progressive democratic nations in the 21st century to practice, embrace, and in some sense celebrate apartheid. And what it's done to us is to make us feel comfortable with the fact that black children are not educated, they're not healthy, they're not loved, they're not cared for, they're not even treated as decent human beings. And so what it's done to us is to make us look like South Africa looked then, and to make a violent, democratic, and progressive South Africa look like we should look now. That's our challenge.
I'd like to begin by offering my sincere thanks to the directors of the Museum of African American History for hosting this event. It is an honor to have been asked to serve on this distinguished panel on such a historical occasion with so many people whom our lives have intersected for the last 20-something years. I also want to thank my colleagues on the faculty at the Southern New England School of Law and the students who drove up from the South Coast to be here this evening to participate in this event. So thank you. I think it's impossible to argue with the analysis offered by Judge Burnham and Judge Gertner. I agree with them that in separating the harm from the remedy, that we ended up with a tragically flawed decision. We continue to deal with the after effects of those critical decisions to this day. It is also difficult to quarrel with the numbers that Mr. Kozol shared with us. The numbers simply don't lie. Having said all of that, I suspect that I am still the most optimistic of the group here as we approach the 50th anniversary of Brown versus the Board. I am optimistic in spite of the fact that there are 9 law schools in Massachusetts, and I am the only dean of color, the second in the history of the Commonwealth. One reason that I am less pessimistic is that the Southern New England School of Law has a minority population of 30%. 22% of our students are of African American or African Caribbean ancestry. My guess is that those numbers are the best in the state. I'd like to think that my presence at the law school has had a little to do with those numbers. I am proud of what we have accomplished in the area of recruiting. I am confident that we can and will do better in the future. The faculty, the staff, and our students have embraced the vision and the mission of Brown. At our law school, we've done all that we can to give meaning to the work of Charles Hamilton Houston, Justice Thurgood Marshall, Constance Baker Motley, and the other pioneers of the legal civil rights movement. While I'm an optimist, folks, I'm not crazy. Clearly, our nation has not made as much progress as it should have since 1954. When Professor Ogletree analogizes America to South Africa, he is absolutely right. They got it right, we got it wrong. My perspective, however, on where we are as a nation vis-a-vis the promise of Brown is shaped by the fact that I grew up in the North and that I attended 12 years of Catholic school. As Carmen mentioned, I was born and reared in Philadelphia. The schools of Philadelphia were integrated in the early 1990s. That's at least 50 years prior to the Brown decision. Recently, I had the misfortune of going through some family photographs after a 90-year-old uncle had died. And I had assumed, like many, that the schools of Philadelphia were segregated. But I saw a picture of his class from 1911, and it was very much integrated. He happened to be on a championship basketball team. Never knew that. But in some cases, the picture doesn't lie, and so I think that that picture gives us a sense, at least, of the history there. I, too, am a Brown baby, and I don't mean just color. I began school in the fall of 1954. Towards the end of my first grade, my parents were summoned to the school to meet with my teacher. They assumed that the news would be bad. In some respects, it was. My white first grade teacher, who I suspect was aware of the mandate of Brown, urged my parents to transfer me from the Philadelphia public schools to the Catholic school in our community. My parents were not Catholic. The teacher told them that I would not realize my full potential if the switch were not made. My teacher and my parents no longer had faith in the public school system that had provided them with a solid education. They were no longer convinced that that same system could do justice by me. From my perspective, the decision in Brown raised the bar for all educators. So much so that my parents and my teacher, by extension, felt compelled to uproot me and to convert to Catholicism. Think about that in 2004. It seems to me, upon reflection, that Brown versus the board is significant for a few reasons. First, it outlaws segregation in the public schools of America. Secondly, and perhaps most importantly, to paraphrase Professor Charles Lawrence, Brown made a statement, and that statement was that African Americans are not intellectually inferior. It mandated that we too are entitled to a quality education. From my vantage point, access to education is the ultimate promise of Brown. Clearly, our nation has not achieved that goal. The work of Brown remains unfinished. In my humble opinion, Brown remains a work in progress. Thank you.
Senator Wilkinson.
It's on. Good evening. Can you hear me? If the dean thought it was unfair, can you just imagine what I am thinking at this very moment? I have to tell you that in some respects, just my presence here on this panel is somewhat surreal to me. And it has a lot to do with this discussion that we're having about Brown. I thought it was especially significant that Carmen introduced us and identified us from where we were born, because I think that where you were born in this country in many ways directs your opinion and your experiences and how we analyze and assess the Brown experience. As Carmen said, I was born in Pine Bluff, Arkansas, in the heart of the segregated South. Within the year, actually, of the Brown, you're not supposed to tell your age, but I'm telling you so because this won't work unless I tell you. Literally within the year of the Brown decision, in the same month of May a year later. And my parents, both of whom were from one Wabasha, or Wabasiki, some of you may know that, and the other Oil Tamer, Arkansas, neither of which exists today, had both come to Pine Bluff, and in that time, that was moving up. Born in my grandmother's house, birthed by a midwife, because we were born at a time when blacks were not allowed, women were not allowed access to public hospitals. My parents traveled to Massachusetts in the late 50s, and it was all about education. That was made clear to us and for us early on, that they believed that going up north to Massachusetts, in part because it was almost as far away as the train would take you from Arkansas. It is not a normal migration. Most people know that you end up in Chicago and Indiana. We went to Massachusetts. And I grew up in the western part of the state. I've been telling people this story often since I came to Boston, because my coming to Boston was really the time in which I began to focus on the import of Brown. And the reason is this. I went to public school in western Massachusetts at a time when, for most of us in that part of the state, Hartford was more associated as the capital than this place they call Boston. I can honestly tell you that as a child growing up through junior high school and college, into college, when I heard about this place called Boston, one of my most distinct and vivid memories as a child is watching black and white television and the pictures of those school buses rolling down the hill, the scared and frightened babies, and what I always thought of as contorted, white, angry people wondering, and no one could ever tell me what they had ever done to make those people so angry. It wasn't until 1977, when I was a senior in college and inquired about a law day that was going to be held at Boston College Law School, because I was coming here to visit the Howard Law School recruiter. And I came to Boston, and it was that time we started talking about this, and it kind of first occurred to me that this place was the same place that I'd been watching on television, because I had never been to Boston, never made that connection. There was a lot of discussion around Brown. versus Board of Education. In part, for me, it did a few things. You have to understand, although I tell you I was in the up north, until I came to Boston, I had never met in the 70s a black female attorney, like live, real. I saw this woman on television named Barbara Jordan in the mid-70s. And when I heard her speak, I said to my sisters, my brothers, my mother, I want to do what she does. And the only thing that I knew was she was an attorney. So I thought if you became an attorney, they would let me go and I could do Watergate, I could be in Congress. And you're laughing, but you have to appreciate, this is real. I had never met a female black attorney. She was the only one that I ever seen. I decided that I was going to law school based on what I thought I knew about her. Never had a chance to meet her. I came here on that day to Boston College Law School campus to talk to the recruiter for Howard and met the students from Boston College Law School, a professor named Ruth Arlene Howe, the dean. I met Chuck Walker, in fact, on that day. Charles Ogletree, as the then president, national president of BALSA, spoke at the luncheon that day. I never got a chance to talk to the recruiter from Howard because I was sold on Boston. I went home and my entire family thought I was nuts. Because this was the place we came up north to get the education that we did not believe we could get in Arkansas. In short, I think what Brown did at that time was affirm for blacks all over this country in a very slow and deliberate way what they always knew and what they had been talking about, and that was an affirmation of the notion that black children, if given the same opportunity, could learn, could read, and could excel. Over time, we learned the downside of what I think was a Supreme Court decision based on a false premise, or at the very least, no plan B. And that was, we said that if we could simply get black children into a classroom to sit next to white children in their school, that by osmosis, by the good nature of white people, that they would share some of what they had with black children. And that we, in some respects, define success as our ability to get black children in the room with white children. And what we clearly never imagined is the degree to which they would go to make sure that that didn't happen. It's clear that at the time of Brown, there was not any notion that they would pick up in mass and leave before they would sit next to black children and allow them to take what I think indirectly the Supreme Court suggested to them was theirs. And so it was never until long after that the discussion began about the mutual benefit of having black children and white children and children of all colors sit in the same room to prepare them for the reality of this nation that, despite all of the resistance that we've seen, is still getting browner. And there's nothing we can do to stop that. I will tell you, as someone who comes at this in the position different from all on the panel, from a policymaker who is still in awe that I was able to maneuver in the very way that Professor Ogletree talked about, that some of us who snuck through, you know, I in large part attribute it to being the tiniest one in my family, and just got missed a lot, and was able to do and focus on things that my big brother, my big 6'2" and 6'4" very black brothers were not able to do, although we were in the same place. The good news is that I too believe that we can beat this, and I think that one of the ways that we beat this is the discussion that has begun today and the last several years, and that is about, okay, if they leave, we still have children to educate. And so the focus is no longer about the goal of sitting them next to white children and vice versa, but fighting for the equality and the resources to make sure that it is distributed in a way that if whatever happens, if the majority of our children are sitting in those public school classes, that they get appropriate resources. And that's a challenge for all of us, because that is what we fight to do every day. But what I will tell you is that I have an opportunity to participate and influence the direction of those resources, but I would never pretend to you that I control them. But I will tell you the people who control them are sitting in this room, out there, and outside this building, and that if we decide that it is a fight to be worth having, we'll have that fight. Because every day we keep talking about the students who continue to excel as the exceptions, and they're not. And so internally we can't internalize this notion that maybe they are, maybe there is something wrong. And I think that today that is part of what we fight every day, that there are as many black people who have doubt in their minds about whether all black children can be educated, which is why that fight is not raging. It should be a raging battle because we spend a lot of money in all the wrong places. There are too many schools. Jonathan talked about this. I challenge people because I will tell you, you have no idea. You have no idea, if you have not been in 3 or 4 Boston public schools in the last year, what the reality is and how sinful it is for us to be talking about a test and a process where the only people accountable are the children. I would say just the last thought about this before we kind of depress ourselves out of here tonight, to remember what Brown did, what Thurgood Marshall did, was carrying their baton in that first leg of the battle. They did their job. They did their job. And the rest of it to do is ours. Thank you. Thank you.
There will be opportunities to take questions from the audience, from the panel, but we're going to have another round of questions, and I would like to encourage our panelists perhaps not to be quite as expansive as we were in the first round. Judge Burnham, we've talked about commemorating the law that Massachusetts passed requiring public schools to accept children regardless of race, and the integration of the Abiel Smith School nearby. But we hear Mr. Kozol talk about schools that are now resegregated. It's still an issue in Boston today, some 30 years after Judge Garrity's decision. State law didn't do it. Brown didn't do it, at least for Boston. What will it take, in your opinion?
I'm going to pass and go for the next round.
You're going to pass and go for the next round? Would you like to take a stab?
Well, I can tell you what it won't, what it will hurt. The law that I was dealing with in the Lynn case was the racial imbalance law, which gave funds to schools that tried to promote racial balance in their schools. And what we need to think about is what the impact of the decline in funds now for public education is going to do. Because the only reason so much of the decision was premised on the fact that there were funds to make the schools excellent. So money, it makes a huge difference in this, and the ability to contribute to support the schools in a meaningful way makes a huge difference in this. And perhaps the best example of that is Boston Latin. You know, and to some degree, my children go to the Brookline High School, which, although is not as diverse as it should be, is still relatively diverse, and it's a school with substantial resources. So legal change in the absence of political will never work in any area.
Mr. Kozol, you spent time in rich school districts, poor school districts, all black, not all black. This goal of integration is still being pursued. Some will question whether it's wholeheartedly or not. But I'd like to ask, what's at stake if we do not integrate the schools? What if we throw in the towel and think of something else?
Well, I'll leave out all the other human and social benefits that I think come from good integrated schooling. And by the way, I have never supported, and I don't know any serious integrationist who's ever argued that black children are going to get smarter from sitting next to white children. That's kind of the argument that people like Clarence Thomas makes that argument in satirizing integration. But I don't know anyone who's seriously made such a preposterous and racist argument. I think we've all argued that equality has proven historically unattainable in profoundly separate schools in the United States. Simple example, I went back a few weeks ago. Just sometimes I have to remind myself what it is that money buys in good suburban schools. Sometimes I actually forget what it's like in a spectacular or simply pretty good school in the mainstream of America, because I'm never in the mainstream. I went, visited, spent a lot of time in Brookline and Newton, and one fairly typical Brookline third grade, there were 16 children in the class, and in all 4 grown-ups, the teacher, a wonderful student teacher, a literacy resource person, and another resource person. I forgot what resource she was bringing to bear. It's amazing. 4 grown-ups for 16 children, integrated, by the way, is a Metco school. In comparison, in a high school that I visited in Los Angeles, fairly typical LA high school, 4,000 students, school so crowded they have to go right through the steamy summer months with hundreds of kids needing to have their classes in squalid-looking trailers because they don't have enough classroom space. There were 40 children in a history class that I was invited to visit. In fact, I asked the teacher, how on earth can you do it? And she said, here, take the class and find out. And I taught them for 2 hours. So the thing is, these gross inequalities have persisted despite legal victories in many, many states, in equity suits. There's something irresistible about the legislative and gubernatorial tendency to defend the inequalities as they stand. In Ohio, they've won 4 Supreme Court victories in the past decade, ruling the system inequitable, unconstitutional. The governor and legislature have flaunted their defiance of this victory. So even when we win, as in New York recently, the children get no vindication. My belief is that the attempt to create equal segregated schools, the Plessy solution, basically, which is all that these court suits are asking for these days, I consider this the longest-lasting failed experiment in American social history. It didn't work in the century that's just passed. It's not going to work in the century ahead. And I would like to see, I mean, I don't deny that you can always find wonderful all-black, all-Hispanic schools in inner-city neighborhoods with terrific principals and who work miracles, and the society loves to point to those exceptions because it seems to let us off the hook. And because they are miracles, and a good society can't be built on miracles. It can only be built on systematic justice, and there's not going to be any systematic justice if we keep on trying to do Plessy.
Thank you. Professor Ogletree, you've studied in the course of writing All Deliberate Speed about Charles Hamilton Houston and Thurgood Marshall and others. Recapture for us their vision of the case law that led to Brown and how that plan was formulated.
Their vision was simple and yet quite complex. Their goal was to make the cost of segregation so expensive that the nation couldn't afford to continue it. And they did that by filing not one suit. We keep talking about Brown as if it's one lawsuit. They had the strategy to file 5 separate lawsuits. They filed a lawsuit in South Carolina, but also in Topeka, Kansas. There was one in Richmond, Virginia, but also in Wilmington, Delaware, and the District of Columbia. And their point was that the Supreme Court was not going to be able to avoid or evade the idea of dealing with segregation. When people think about Brown next Monday, they'll say, oh, we integrated the South. The problem was a national problem, and that's why they were in Topeka, Kansas, and in Wilmington, Delaware. And that's the brilliance, that they had the foresight to say, let's not just file a suit, but they filed a variety of suits. The second thing is that they had an extraordinary strategy that isn't used often anymore, or considered often anymore, or considered effective, and that is that they had social science data. That is, we're not just going to give you data and statistics about the quality of the schools. We're going to give you expert testimony. We're going to tell you what's really going on. We're going to put on the parents, the children, the teachers. And so it wasn't just a legal argument, but it was a case history of the different lives. And you can see that the lives were entirely separate and equal and unequal based upon race. And after that, they also chose education because they thought about what employment, there's going to be a battle, housing, there's going to be a battle. But who could not agree that children who are innocent, who have no power and no authority, should receive a quality of education? Elementary school children. Who would argue with that? Well, they didn't realize a lot of people argued with that simple proposition. But the other point that's sort of lost in history is that the reason I think Brown is significant is that Brown was the beginning, but after Brown then they started talking about, well, let's move from schools to hotels, to jobs, to all sorts of training, to swimming pools, to golf courses, to parks. Let's take this to transportation. And they had the idea that once we won the principle, let's continue to apply it in a wide variety of ways that's significant. And the final thing I'd say about these lawyers, and it was captured so clearly by our Senator Dianne Wilkerson, is that they really did their job. I mean, they won this case against a very conservative, all-white, all-male, skeptical Supreme Court that had upheld the doctrine of separate but equal from 1896 to 1954. 58 years, that was the law. And that Supreme Court, even though its composition had changed, had affirmed the doctrine of plessy over 40 times before these lawyers came and changed the mind of the court in a unanimous way. And so Brown's not the problem. Brown made it clear that what we have is wrong. We are the problem, because we're saying, okay, you can change the schools, but you can't make me go. You can't make my children go. You can't make me live in the neighborhood. You can't make me be friends with somebody. You can't address private discrimination, and they're right. The court can't address private discrimination as a constitutional matter. So those lawyers were what I say in the book. It's the true and only ever, the original dream team. Talented, brilliant, committed, creative. And the last thing I want to say about what they did was to show us that a group, not exclusively, by and large, a group of African American lawyers trained at segregated African American law schools had the brilliance and the insight to open up America's institutions of higher education for all of us when they could not attend the very institutions that they integrated. That is a classic sense of selflessness and sacrifice. They opened the doors for us that they could not walk through. And so next Monday, when we talk about the case, talk about Earl Warren, we're talking about the wrong thing. We're talking about places like Howard University, training and educating lawyers who had an attitude. And the attitude was we weren't going to lose. There was no idea of losing at all. And I think the legacy is that there has never been a group of lawyers in this country like that that's come this way since those lawyers who came here in the 1950s. And we don't know their names. We don't know their pasts. We don't know their histories. But if we do anything on May 17th, it's not to celebrate the decision, but to celebrate the faceless, nameless, voiceless, and now often forgotten lawyers educated at HBCUs who sacrificed everything to make it possible for all of us to be here And we are, in a sense, their voice today. And they wanted us to be at Harvard and Yale and Stanford and Michigan because those are institutions that deserve to have the best. And the best is a rainbow of people who are black and white and brown and yellow and bilingual and international and domestic and women and men and poor and rich and conservative and liberal. That's what they wanted, and I hope that we can make their dream continue to come true.
Thank you. In the interest of time, we're going to move to the questions from the audience. If you have a question, raise your hand. I'll recognize you, and our young lady who has a microphone will get that over to you just as rapidly as possible so you can be heard by all. Questions for our panel? Yes, over here. Can you stand, please? But while she's moving there, because of the time, I would encourage us to ask questions and not make statements, if possible.
Yeah, just question with regard to the point that Mr. Kozol brought up. The reality is that there are still segregated schools today, and I know that the question came up about how to make resources equal and recognizing that's the Plessy solution. Aside from that, I just wanted to hear what would be your remedy. Let's take an all-black school, let's say in the South Bronx or in, someplace in California or someplace even in Boston, and what would be a posed remedy now to create the kind of situation in the school that Brown envisioned, equality?
Good. Obviously, we have to win what victories we can within the moment, while we're also dreaming and struggling, I hope, to topple the walls. And I'll give you one concrete example of something I think it would be relatively easy for America to do, and I'm surprised that no political leader, including the Democratic leaders whom I'm close to personally, have dared to support this. We ought to make profoundly rich, developmentally textured preschool education, starting at the age of 2.5 at least, along with allied parental programs and medical screening and all the rest, universal for the poorest children in this nation, which would also mean virtually all the children who attend these hyper-segregated schools. Some of you may think, because some of you are as old as I and remember when Head Start began. I remember when it started. My beloved ally, Thelma Burns, who's in the audience here, one of the METCO leaders, and I ran one of those programs almost from the beginning, the Head Start programs. To this day, in the inner city neighborhoods where the largest numbers of deeply impoverished children live, you will find typically not half, not 1/3, but less than 1/4 of the kindergarten children, if you ask their teachers, got any kind of preschool before they entered public school. 2 years later, we start testing them, thanks to our president in Washington, who believes that testing is the best form of education. So these kids have had kindergarten, first grade, second, before the tough high-stakes tests begin. Meantime, the children of my Harvard classmates in Manhattan, for example, typically get 2 or 3 years of wonderful privately paid for preschool education starting when they're 2 years old. It's common. The best ones in New York, the ones people fight to get their kids into, cost $20,000 a year. All-day programs with both play and fun and social development and rich academic content. The best ones in New York are called the baby Ivies. Why? Because they're considered the first step on the royal road to Exeter and Harvard, right? The kids I know enter school 2 to 3 years developmentally delayed, not dumber, but developmentally retarded behind the children of the privileged. I think it is outrageous to give high-stakes exams to kids 2 years later if we first denied them the opportunities for preschool. I think it's particularly outrageous to demand accountability. That's the buzzword. To demand test accountability of little 6 and 7 and 8-year-old Black and Latino kids until we have the nerve to hold the President and Congress accountable for cheating these children of what they give their own kids, starting 4 years earlier. Okay?
Professor Ogletree, could you please comment on the phrase used in the Brown decision that has the effect of, in a sense, undermining the decision? With all deliberate speed, why didn't the court say immediately?
There's no good reason that they didn't say immediately. That's exactly why I gave that title to the book, to talk about the complexity of Brown. It's absolutely an important decision that they reached in 1954, ending segregation. It made no sense at all, in my view, to wait a year after you've won before you have a remedy. And that remedy, even then, was very compromised by, in a sense, signaling to the South that they could take as much time as they wanted before segregation had to be the law. And it's even more complex than that. I wish I could say it was just a few Southern segregationists, but it amazed me when I did the research on this book to learn things about not just the Southerners, but even our president. President Dwight Eisenhower made the statement when after the decision was issued, he told Chief Justice Warren why he was troubled by Brown. He said, Southern whites are not bad people. All they're concerned about is to see that their sweet little girls are not required to sit in school alongside some big overgrown Negroes. Now, this is the President of the United States. And if that's his attitude, imagine what it meant to the communities that surrounded it. And what the court did was actually give the argument to the South in terms of how to resist. That is that, all deliberate speed, we can take our time. And you think about that. If you win a case in court today, the court says, okay, come back next year to get your money. Or if you get convicted, say, oh, you have to go to jail, come back, let's put that off. We'll sentence you with all deliberate speed, right? That's not the way the system works. When you have a right, then there should be a remedy to follow it. And it makes no sense at all. And that's precisely why this title is here, to remind us forever, as important as the victory was, a year later the court took away the moral force of it by giving the world the sense that it could be done with all deliberate speed.
You wanted to add, Dean Ward?
I want to say something, because part of what we're going to need to do is to leave here with an agenda, with hope, and there's a new battle that is brewing, and we cannot stand on the sidelines. Judge Margaret Botsford, a month or so ago, rendered a decision which could change the way public school education is funded in the Commonwealth of Massachusetts. Given what we have seen happen to judges who try to do the right thing, if we stand silent, the game is over.
Thank you very much. I think that looks like the microphone is coming. I thought that was Bill Wright, but that's not.
Good evening, and again, thank you all for coming. I'm going to ask my question as a challenge to the panel because of the question that was posed to the panel earlier, namely, has it helped us, has it hurt us, and basically what can be done? If I were to put forth the following hypothesis, that the same mind that does not understand the reaction of the Iraqi people, that does not understand the reaction of any oppressed people of color, it's the same mind that is comfortable with the resegregation of public schools. Would that challenge you to think about why 50 years after Brown, the need for readdressing the issue of segregation is not resonating in the American mind? I'm asking what must change in the conversation so that the American people so this begins to resonate with the American people. Because again, I see the same struggle with a small group of us and the majority of the public, including our own people, not bothering too much with this issue at all. So that's my challenge.
I want to call on Senator Wilkerson to answer that, which is the last question, and then I will turn the meeting back over to our Executive Director. Senator Wilkerson.
Thank you, and I think I'll answer hopefully the first and the last question in response. First, there are some things we can do. I think one of them is we have to do the math. If you're in the city of Boston, in our public school system, where 82% of the children who attend are children of color, and 18% are white children, unless you're going to chop them up, there just aren't enough of them to go around. I mean, part of what I think we have to do is stop this incessant search for more white children. We have a system where 62,000 children are there, and today they deserve to get an education. I mean, and so perhaps it will change over time naturally, but our focus is misdirected. The focus, the 4 cities that you talked about in the Judge Botsford decision, none of them are urban cities. So even if they get more money, it's likely to come from Boston or Worcester or Springfield. And the why is because Boston, Worcester, and Springfield right now receive sinful and embarrassing amounts of money. They do. We don't spend it right. That's what we're missing. That somehow we have the largest budget of any system in this Commonwealth, and half of the children do not have books. Something's wrong. And it's not that they don't have a per pupil expenditure sufficient to do it. We have not been following the dollars. So that would be one, that we have to redirect our energies to this. And doesn't mean that we don't need any more money, but it means we don't even know where the money we're spending right now is. Second, I think we have to stop talking in code. When people say that the problem is that the majority of those children come from single-parent families, I always say, what does that mean? That we're like inherently moronic producers of children because we're single parents? No, because most of us in our generation, many of us, also came from single parents. But that didn't mean that we were not going to be learning in school or that we were ineducable. So every time we hear that and let it go, we're helping perpetuate this myth that, by definition, if you have a single parent, you can't expect anything from them because they can't learn. The other thing is that people... We have right now an Education Reform Act. In fact, I'm proud to say, Jonathan, that today we execed out our Senate bill, and it has universal preschool for preschoolers in Massachusetts, 3 years old. I just think what we need is a re-engagement by all citizens, and not those who were unfortunate enough to figure out a way to get out, in the support of the public education of our children. The very existence, the entity that we call public education is hanging in the balance because every day someone has come up with a new way to pull a little bit away. But 93% of black children are still sitting in classes in public school. And just finding more white children to sit with them is not going to make it better, because what we also learned, at least in Boston, is that they would destroy the system and the opportunities even for those children to keep black children from getting it. 28 public schools in Roxbury and Dorchester were demolished or condominiumized from 1974 to 1983 for the express purpose of not having a building to send white children to. So that the only thing that could happen was that we would bus children out. So when we start talking the present day conversation about reverting to neighborhood schools, that's fine if you have a school in your neighborhood. They don't exist. We tore down and sold off 28 schools in Roxbury and Dorchester. And that's where the overpopulation of students. And so the focus has got to be on making sure that the resources we spend are spent in a way that is proportionately sufficient to get to this quality education that we're talking about. And I think it can happen. It doesn't mean we don't need more money, but I will tell you an awful lot of black folks for the last 5 years have been focusing all their energy and stopping MCAS. I said to them, you can make that fight. I will be in there trying to figure out where the money is. Because the reality is that, like it or not, Johnny can't read. Okay? And for us to be giving him a diploma that he can't read is not servicing him or anyone else. And so we have to fix it, and we can't fix it by blaming Johnny, because a whole lot of us that were part of this system fell down on the job. When children are held up and supported and loved and cared for, and they become the focus of attention, they learn in the ugliest, most run-down environments that can be. So if our goal is we can't teach them until we get a brand new school, then I think that's a cop-out. We can do better than this. And I think that there are people who I hear and I see every day have begun to figure out that we have to be chasing these dollars. Thank you.
Thank you, Professor Burnham, Judge Gertner, Mr. Kozol, Professor Ogletree, Dean Ward, Senator Wilkerson. May I now present Beverly Morgan Welsh. And thank you, all of you.
My. The museum loves having these conversations, and I too want to add my thanks to all of the participants. And while your gifts aren't as big as Mrs. Marshall's, we do indeed have gifts for all of you, and want to thank you. I want to thank a few people, and you should understand, I think that perhaps as Mrs. Marshall was talking, you may not have quite realized when she said her sisters-in-law were here, exactly who was present. Kathy Douglas Stone, a member of our board of directors, is the person who invited Sissy Marshall to be here this evening. And that is because they belong to the same sisterhood, that of spouses of Supreme Court justices of the United States of America. Kathy's husband was William Douglas, Chief Justice Douglas. And so he has passed away and she is married again. But also we had present from Plymouth Plantation, the executive director there, Ms. Brennan is the daughter of Justice Brennan. And the Chief Justice's wife, Brewer, was here as well. So, I'm sorry? Breyer, I'm sorry. So you do see that we had a number of people as part of that Supreme Court world that were here to join her and acknowledge that and paid us all honor and homage. I want to thank a few people that organized this evening. The Honorable Charles Walker is a member of our board of directors, and as we talked about the necessity of doing this program, I asked him if he would help to organize it, and he did. And I always love it when people bring smart and committed people with them to help. Portia Cupid of Kirkpatrick and Lockhart and Sonia Skinner of the City of Boston Law Department also helped in the planning, and I want to thank them as well. I also want to thank one of the museum's newest best friends, that is the Reverend Laurel Scott. Old West Church was built again in 1806. The floorboards at the African Meeting House came from the original Old West Church. We thought that it would be entirely appropriate to continue that incredible relationship born in 1806 by joining in partnership with Old West, and the Reverend Scott has been the most wonderful host, and we want to thank her. I recently attended a conference for the National Trust for Historic Preservation of African American historic places in this country, and I talked about the Board of Directors of the Museum of Afro-American History. As I showed Mrs. Marshall around the museum and explained to her who the board members were and what they were doing on behalf of the museum and who our volunteers were and who the park rangers are, she first of all said, I don't believe you can make people work that hard, but it is not a matter of making them work that hard. It is their personal commitment. If the board of the Museum of Afro-American History would stand. On behalf of that board, I want to thank all of you for being here. We are going to immediately adjourn to a book signing. The books are available here, Professor Ogletree's books, and he will be over here signing them. But I would also be remiss if I did not thank the staff of the museum. There is one person who has planned this event and done a fabulous job. I also, because I'm now old, I had an operation a couple of weeks ago, and she had to act as director of the museum while at the same time planning this major event. She is an incredible woman who is committed, who is brilliant, who is kind, who is lovely, who is beautiful, Chandra Harrington. I also want to say to you that there are membership brochures in the foyer. If you think any of this happens, we're in a church now. My husband's a minister, so I'm about to take a moment of privilege. None of this happens without your support. If you are not a member of the museum or you do not donate to the preservation and the continual education of people about this incredible history, then it won't continue. It is the support of every one of you and people around this Commonwealth and around this country that make this kind of a dynamic panel possible. We sit here in this room in a country that is on the brink of disaster. If we only knew that Prince Hall and 66 others opened a school on Beacon Hill in the home of Primus Hall in 1798, after petitioning the legislature for access to education in Boston and finding that it fell on deaf ears, those 66 African American men and women in this community formed a school. Brown v. Board didn't begin it. It's a part of the continuation. They understood that knowledge is power. There's no way to follow the numbers if you can't count them. This community has a long history. This community is part of this important nation's history. If we knew this history, we would be a different people. Justice might indeed roll down like thunder. When you leave here this evening, I want you to send a voicemail, a text message, snail mail, right in your journal. When I picked up Mrs. Marshall this morning at the airport, I telephoned my 11-year-old on her digital cell phone and left her a message telling her where I was, telling her that I was picking up the wife of the first African-American Supreme Court justice in this nation, that I wanted to understand her to understand what I was doing this day. I wanted her to understand that I went to Smith College because of Justice Marshall and those others on the team. Their lives weren't limited to Brown v. Board. Constance Baker Motley gave me a call when I was in Hartford, Connecticut, and told me there was a collection of 7,000 objects of African-American art and artifacts. She told me to go get them, bring them to the Wadsworth Atheneum, and make them available to the world. They weren't just attorneys with a creative and wonderful idea. They were fully orbed human beings that gave of themselves, just as the black patriots who lived in this city gave of themselves then. If we took the intellectual power, the economic power, the humanity, the love, and the force of your goodwill and turned it toward the education of our children, we would be a different city, we would be a different state, and we would be a different world. Come to the museum, record this event. We've made history here this evening. Thank you.